Welcome to Tort Talk. We are 1 week away from MTMP in Vegas, next week at the Wynn, and today we are celebrating the Michigan Wolverines national championship in basketball.
Go Blue!
Thank you. Thank you very much. I'm a very, very happy man this morning, even though I only got about 4 hours of sleep. Today, we are going to be doing the power rankings for April. It has been about a month since we did our power rankings, and there has been so much going on in the world of mass torts that we needed to go through all the different mass torts that you potentially should be looking at gaining cases in. These are specifically based around the case types that you should consider potentially looking at acquiring more cases for. Joe is going to talk to you about each of these one by one, and we're going to go through the pros and cons of each, what's trending up, what's trending down, and what may be coming soon and be discussed at MTMP next week and Mass Torts Puerto Rico in just about a month. Marc, are you ready for it?
I'm ready. I prep for this. There's some new mass torts making the list that were not on here the past couple weeks. So I'm very excited for the audience to learn what they are.
Congratulations, John, on your big win there. I know it must feel good to be on top of the world. We'll see what mass tort ends up at the top of the power rankings.
If your law firm's marketing is not helping drive signed cases, what exactly is it doing? At RR Digital, we build for the outcome that actually matters. SEO that gets you found, paid ads that bring in qualified leads, and social media that builds trust even before the first call is even made. RR Digital was built to help law firms grow, and signed cases is the metric that we care about. Ready for more cases? Let's talk. More information at rrdigitalmedia.com. Back to the pod.
We are going to get started at number 10. At number 10, we have Bair Hugger, still staying in the top 10 from last month. There's a trial scheduled for 2026. This has been around for about a decade. Can the pressure from that trial bring about a potential settlement, Joe?
That's what we're all hoping. So this is one of the legacy mass torts. I think it's one of two legacy mass torts in the top 10. We have more than 9,000 cases. And what's going on in this litigation is the pressure's really coming outside of the MDL. So there's a lot of state court proceedings that are hopefully on track for trials in 2026, maybe towards the end of the year, a trial in Philadelphia. We have hopefully trials coming up in Minnesota State Court. The cases are getting worked up in the MDL. The cases then are supposed to get remanded. So hopefully this pressure can get these bear hugger cases resolved. We haven't seen large groups of cases settled. There's been a few cases that have settled so far, but hopefully we can get this pressure on 3M and get this whole inventory resolved later this year.
That's a tort we're really looking to see some progress made on in 2026. Number 9, we have the opposite of Bair Hugger, which has been around for a while. We have Dupixent, which is a newbie on our power rankings. We have a pending motion to consolidate and form an MDL that was filed a couple of months ago, February 13th. Do you think Dupixent really will be the next mass tort?
I do, John, but with this one, I want to caution everybody. I don't think we're going to have a huge number of mass torts cases like we typically see, and maybe Talc or Roundup, or even get to the 10,000 threshold in Bair Hugger. I think we're going to have a couple thousand cases. It's ripe for an MDL. The injuries are significant. The science seems to be pretty strong. So this is one that everybody's definitely going to be talking about at MTMP. Not a lot of buzz about it right now. We'll probably have an MDL formed after the next JPML hearing later this year. But this is one that's going to be with us for a couple years, I'd imagine.
It'll be very interesting to hear what people are saying at MTMP on this one. It is so fresh, so new, and with the limited amount of potential cases, we'll see how far it goes. Coming in at number 8, we have the largest mass tort in the world, talcum powder. A lot of attention's been paid on the arguments between J&J and Beasley Allen, but what is actually going on with talcum powder?
That's a good point, John. What we really want to focus on is the litigation. As you mentioned, we have almost 70,000 cases pending. We're really trying to get towards more trials, as we always are in these cases. We had a good ruling, as you remember, earlier this year on experts in the MDL. We had a trial in Philadelphia in state court. That was a verdict for plaintiff. Definitely less than what we hoped. But later this month, there's a settlement conference that's scheduled. I'm hearing some optimism, very limited buzz about optimism about maybe a resolution in this case. I think all of the attention for the last 6 months has been on Beasley Allen versus J&J. That seems to be behind us at this point. Hopefully we can get some momentum coming out of this settlement negotiation conference and then ultimately get these cases resolved. I think we're going to have to try a couple more cases, but I do think we are going to see the end of this litigation likely before the end of 2026.
Would love to see that. It's been going on for so long. These claimants have been through so much. These law firms have been through so much with the bankruptcies. Hopefully, we can make it to the end before the end of 26.
That's an unfortunate development. We see in a lot of these cases, right? We know one of the strategies the defendants deploy is delay, delay, delay. They want the claimants to die, the memories fade, maybe their families don't end up, opening an estate, and then they walk away with nothing. So we see it all the time, but especially these cases, these cancer cases, it's a big problem.
All right, coming in at number 7, we have the GLP-1 weight loss drugs. As we've been talking about for many months, these parallel paths for the vision loss cases and the gastrointestinal injuries. What comes next in the weight loss litigation, Joe?
Like you mentioned, John, we're looking at these together. When people are advertising, I think you could do an advertisement for either the gastro injuries or these vision loss cases. The vision loss cases keep getting stronger and stronger as time goes along. Everybody's really excited about those. I just want to caution everybody. I don't think we're going to see a huge number of those cases out there. It's probably looking in the thousands, whereas with the gastrointestinal injury cases, we're making some really good progress with that. The injuries really are focusing on gastroparesis. So about 75% of the cases are focusing on that injury. That's almost developed as our signature injury. So we're going to keep working those cases. The gastro injury cases almost have a 2-year head start on the vision loss cases. So we'll probably get towards some bellwether scheduling in 27. I don't think we'll have a trial set yet, but hopefully before the end of 27, we could have some good rulings on experts and the bellwether cases worked up. And then maybe that brings it a resolution. But the vision loss cases, they're going to be dragging behind for a couple years.
Coming in at number 6, we have the first of 4 technology platforms in our top 6. We have video game addiction. Are people still excited about this litigation?
I think you made a good point, John. This is crazy to think, even 2 years ago, if you tell me that 4 of the top 6 mass torts out there would be involving tech companies, I wouldn't believe you. I mean, we've just seen this complete shift in what's the focus of these litigations. And I do think people are more excited than ever about these video game addiction cases. We saw that verdict that came down in the social media addiction. We talked a lot about it, but that really spurred the excitement. It's a similar type of theory going on in these video game addiction cases. We have some litigation ongoing. We don't have an MDL, but there's still a home for these cases. And as time goes on, I think pressure that we're seeing in this video game addiction, along with the pressure that we'll get in the social media addiction, will ultimately bring about some sort of resolution and then change to the platforms, which we really need and is evident by everything that's going on.
Yeah, video game addiction, there's a lot of buzz about it last year at MTMP, and it kind of died down. And you think it's really making a comeback, huh?
Yeah, I do. It's nobody's talking about it on the level as they are with the social media addiction, but I think it's a viable claim. We have some good attorneys and good firms that are involved with it. It's been in the work for a couple years, so I do think we're going to end up getting a resolution in that. And it's probably the least talked about tech claim that's out there, but it's pretty mature compared to some of these other cases. So I would I would encourage people to get involved in this case as well.
All right, we're taking off the hat. We're getting down to business now. We're in the top 5. Coming in at number 5, we have the app that my children still ask me to play every single week, and I still deny them. It's Roblox. Another tech in the top 6. How is this MDL shaping up?
It's coming together pretty well so far. We have a lot of really experienced law firms and attorneys that have been appointed to leadership. These cases are really severe. So the injuries in Roblox cases pretty much are more severe and more extreme than what we've been seeing in the video game or the social media addiction. The criteria is getting a lot tighter here. We're really focusing on a lot of cases that involve, physical contact, taking it offline. So we know these platforms are really dangerous to kids. I think it's good that that's getting out there, but we're just getting our feet under us in this MDL. expect to see a couple scheduling orders coming out in the next couple months that will really set everything up for us. We'll end up going through the motion to dismiss practice. They're really trying to get the cases into arbitration. Hopefully, we're able to beat that back. Then the litigation will open up where we'll have some sort of master filings. We'll do the discovery process, and then hopefully we can have a fast rocket docket like we've seen in Depo-Provera and really push these cases aggressively towards some sort of bellwether process.
Joe, what's your perspective on multi-platform communication? When you have someone who is engaging with a predator on Roblox who then moves the conversation to a different platform, how do you see that playing out as the Roblox litigation specifically develops?
It's definitely going to be something that's common. I think these predators have that down. But as far as liability, there could be liability on multiple platforms. But I think the one that's going to be most culpable is going to be the platform where that initial interaction really started. The problem with Roblox is they were allowing people to just create these fake accounts and they didn't have the safeguards in place to verify who they were or verify the minors. So I think that's really the problem with that. But you could have a case where you have a plaintiff, for example, that could, have a video game addiction or social media addiction, or somebody have a Roblox game and then have a separate video game addiction. We're looking at a little bit different injuries in the Roblox from the social media addiction, but that is a problem. And you could potentially sign up a claimant for multiple potential claims. So that's a good point for people to be on the lookout for that.
I wasn't even thinking about signing up for multiple claims. I was thinking of that famous Spider-Man meme where you've got the multiple Spider-Mans just all pointing at each other, right? And in this situation, you could have Roblox's defense saying, "Oh, well, they couldn't communicate on our platform, so they had to go to a different one, so we're not liable. We put the protections in place." And then maybe you have a Snapchat or a Discord where the communication escalates and leads to the in-person assault, pointing back and saying, "Well, if it didn't happen on Roblox, it never would have been an issue." It'll be very, very interesting to see how this develops.
Yeah, definitely. They'll, ultimately apportion some sort of liability to the different platforms. That's how it'll work out. So I think they'll factor in how many hours were they using something. And then I really think that initial contact, that initial association is going to be, the determining factor, at least in my opinion, where a lot of the liability should lie.
At number 4, you briefly mentioned Depo-Provera and the Rocket Docket. Depo-Provera comes in at number 4 this month. It's the fastest moving MDL in history, has us on track for a trial in December 2026. What needs to get done in order for us to get there and potentially be successful for the plaintiffs at that first trial?
Yeah, this docket's crazy. I haven't seen anything like it. We're a little over a year after it's been formed, but it's going along at this rapid pace. I know me and Marc talked a little bit previously about seeing 1,000 filings in a month. Right now, we're up over 5,000 cases. So we're still waiting from the judge on the preemption ruling. That seems like a slam dunk. We know that the defendants actually ended up updating their warning label, just like we said they should have from the beginning. What we're doing now is working up these individual cases, kind of sample cases. They're getting worked up like bellwether cases. And ultimately, we'll get a ruling here, I would expect in the next 2 months on the preemption. Then we're going to end up hearing from the experts. We'll get a ruling probably before the end of the summer on the general causation experts. And then when we get into the fall and the winter, we'll get the case specific workup. So it's going along amazingly well for the plaintiffs. The documents are bad for the defendants. We have a judge who oversaw 3M, as you remember, Judge Rogers. She's doing a great job, and everybody's really excited about that.
At number 3, we have Uber sex abuse. Staying in the top 3, we really haven't heard too much news about this since the last trial ended. What will the next bellwether trial tell us, and what's the current status of the overall litigation?
Right. So we're seeing more pressure on Uber right now. We're gearing up for the next bellwether trial. So again, this case is an MDL where the judge, instead of holding the trials in the MDL before that court, is remanding and sending them out to the district court where the case would have been filed. So right now, we're gearing up for the next trial in North Carolina. In this case, we saw that the judge came down and ruled that Uber is what's considered a common carrier. So that means that they are going to be responsible and liable for the acts of the drivers. So they're fighting that right now, but the case is moving towards trial. We'll have that here in the summer. It looks like we developed the playbook and what was needed to get a good number in the verdict in the last trial. So that's going to keep going on. Meanwhile, we still have the state court action proceeding. And I've been hearing some rumors that some of these Uber cases are settling. It doesn't mean there's a global settlement in the works right now, but it seems that Uber's kind of changed tactics a little bit. These one cases with severe injuries, really clear records, maybe the hospital reports and police reports backing it up. They've been resolving some of those cases, allegedly. And it seems like now they're thinking about how to kind of resolve the litigation overall instead of fight, as we saw in the beginning, likely because they've changed some of the terms of their user agreement and have made some changes to the platform.
Yeah, last time I ordered Uber Eats, I was forced to accept their new terms and conditions. So I think we're dealing with a trickle down effect of what happened with the social media addiction verdict. The platforms realize they are no longer immune or potentially immune. Is this next Bellwether trial a plaintiff or a defense pick?
I believe it's a defense pick.
Won't hold you to it. All right, we've finally hit the top two. Number two, we have hair relaxer, which last month was at number one, which means we have a new number one, Joe and Marc. Hair relaxer has over 11,000 active cases in the MDL. Where do we stand in the litigation?
Yeah, it's going forward really well. Parties were instructed to select and propose some bellwether cases. The judge didn't like the selections by the parties. Basically, she came out and said these cases aren't representative of what true bellwethers are. There were all these other issues that could distract the jury. So she entered an order just last week that identified I believe it's 10 bellwether cases to get worked up. Those cases are going to get worked up further here. The individual workup of depositions of plaintiffs and the doctors and then the experts. And then ultimately, we're looking at a trial about a year from now. So, a lot of excitement in that litigation. Is going forward pretty well. We'll have a causation ruling on the general experts likely this summer. I'm feeling optimistic that all three of the cancers are going to survive the uterine, endometrial, and ovarian cancer. And then we'll gear up towards the bellwether cases. So, this has been a long, hard fought case, a lot of different defendants, a lot of different products. And that's why it's a lot more complex than, say, Depo-Provera. But we have some good momentum going here. I think we're going to end up with maybe 15,000 total cases. I still love this case, but it did get knocked off the top spot. And that's for a pretty obvious reason.
Yep, rightfully so. And before we reveal number one, which many of you can probably guess, let's talk through the ones to watch and what we're waiting and seeing on. And in the wait and see bucket, we do have Tylenol. We're still waiting on the Second Circuit to potentially breathe new life into this litigation. It's kind of been off again, on again for Tylenol, but that one's still holding tight while we wait to see what happens there. In our ones to watch, surprised it didn't make the top 10. I'm a firm believer in this one. Barred PowerPort. A positive jury verdict in the first Bellwether trial could have a lot of excitement added to this litigation. We'll see whether or not that actually happens. And then one that I'm hearing a lot of underground buzz about, the Olympus Scope infection cases. Obviously, a lot of people have had scopes done, whether those are colonoscopies or other types of scopes. Olympus is the largest manufacturer, I believe, of these types of scopes. Very new litigation, a lot of buzz around this. Joe, just for those who don't know about this litigation, can you give a brief overview of the Olympus Scope infections?
Yeah, it's just starting out. Like you said, John, we don't even have a JPML petition filed yet. So realistically, I'd imagine it comes on everybody's radar in the fall of this year. But basically, it's a huge manufacturer. Thousands of these products are used every day. And basically, it's causing and contributing to infections on people who have an Olympic scope during a procedure, like you mentioned, and then later the next day, within a few days, develop an infection, end up needing additional treatment, sometimes additional surgery. So this has the potential to be a huge mass tort. And when I say huge mass tort, we're looking at more than 20,000 potential cases. This could get really big. So stay tuned. Everybody's going to be talking about it. I think it's a level below the excitement we have for our number one, but I know we're going to have an MDL formed, and I know everybody will be talking about it out in Vegas.
Yep, absolutely. Speaking of number one, the Michigan Wolverines. Coming in at number one, social media addiction. So, social media addiction has been the talk of the town for the past 2 weeks since the verdict. Some may say the trial of the century. Section 230, I think, effectively, as a viable defense, is over. We kind of knew going into the trial that was the case because of past rulings, but we saw it come to fruition with the $6 million verdict against Meta and Google's YouTube a couple of weeks ago, heralded by Marc Lanier of the Lanier Law Firm. Do you still think there's opportunity to get involved, Joe?
I do, and that's why we have it at number one. There's still a ton of cases out there. This case isn't going away today or tomorrow or next month. And so there's a lot of potential users out there that need our help. The case and the science has been pretty worked up. We know what the signature injuries are. We know what the demographics are for the plaintiffs. We know that these defendants will either pay or ultimately be told by the jury to pay. So still some time to get involved in this case. Everybody's going to be talking about it at Mass Tort Made Perfect. Every other conversation you have will probably be about it, but just let them know that we think there's still time to get involved. If you guys have questions about the criteria or what a case really looks like, there's different tiers. Reach out to me or John and Marc. We'll give you guys some insight, but be careful when you're getting these cases, but there's still a lot of time to get involved.
Yep, absolutely. Super excited about this one. Love to see that verdict that we had a couple weeks ago and excited for the future of the litigation, not only from a business perspective, but I do think that this is the right thing to do to protect people from these platforms. And it is setting the table for a lot of these other platform-based litigations, as we talked about earlier. That being said, we are wrapping up this month's Tort Talk Power Rankings, and our next Tort Talk we will film in Las Vegas at MTMP. We were only 1 week away.
It's going to be two things. It's going to be social media addiction, and then it's going to be Olympus. So those are the two ones, and then hopefully we get word, maybe some good updates on Talc about a settlement coming down the pike.
Yeah, don't we have a deadline coming up?
For Talc, you're saying?
Yeah.
Yeah, there's a settlement conference scheduled. We've been working with the mediator there for a couple months now, but like I said, I'm hearing buzz. Some people are getting a little bit more excited. If you're watching the docket filings, that's a good place to get a tip off. We've seen a big increase in some of the filings, so if you got cases, get them on file.
Excellent. As always, thank you, Joe, for joining us. And we will see everybody next week in Las Vegas for MTMP. This is Tort Talk.